My name is Prokopios Drogkaris and I'm within ENISA, and we were supposed to have Miss Jelena Brunik from the Slovenian Data Protection Authority. Unfortunately, she could not be able. She's not able to join us. But still, I think that we will manage to have a very lively and interesting discussion, even without having been able to hear the perspective of the National Data Protection Authority in this panel. As I mentioned before, this panel session is about the European Data Protection Certification Scheme. As you may know, GDPR strongly mentions, or it's one of the new additions, personally it's one of my favorite, on certifying on data protection certification, privacy and seals. Mainly it's included in order to enhance this certification aspect, is included to enhance transparency of the various processing operations. In order for the data controllers to demonstrate compliance, roughly, put it like that. So, I would like first to ask Sebastian, having the experience from such a certification scheme, how feasible do you think it is to talk about EU-wide certification framework? This EU-wide certification framework for data protection, it's up until one extent my translation of the General Data Protection Regulation, but my understanding is that we cannot go again, since we're talking about a regulation and the European Data Protection Board. I don't think it makes sense to talk about national or partial national certification scheme. How feasible do you think this is, and what experience do you think that regulators and the European Data Protection Board could draw from these existing initiatives?
Yes, of course. I think it would come as a surprise if I would say it's not feasible. Of course, I'm deeply convinced that it is feasible based on the experiences that we made in the past. So actually, it's to this very day, it's 10 years ago, we started with a kickoff meeting for the EuroPriSe project at that time. So we really have a decade of experience with a seal on EU level. And I certainly think that this is feasible, but it brings a lot of challenges, which also will not surprise you. It was a huge challenge under the current directive to deal with national laws while trying to be an EU seal, and we still will have to face challenges regarding the opening clauses in the GDPR when we we'll try to establish a real European seal in the future. So there are quite some challenges, but there are also many opportunities here, because previously the most important driver for a company to go for certification was really, to my best knowledge, a B2B requirement for some sort of certification, to demonstrate as a service provider particularly that you have, for example, appropriate technical organizational measures in place. This can be a very strong driver, but if your customers do not require you to go for that, then why should you at this point in time go for certification? I would know good reasons, but most companies would then argue, I cannot see the reasons right now. With the GDPR, we have incentives in the law. So in the law itself says that certification can be an element to demonstrate compliance. Of course, still data protection authorities will have the competence to investigate if need be, and it cannot be otherwise. But there is this first incentive, and of course there is an incentive that when talking about administrative fines, seals and certifications have to be considered or should be considered by supervisory authorities. If we think of privacy by design, one recital explicitly mentions that privacy by design, if implemented properly, should be considered in public tenders. So if a certification covers privacy by design, then the same will hold true for the certification, of course. So there are quite some incentives. There are also a lot of challenges. And maybe for those of you who are not aware of what the European Privacy Seal does, I will be very brief here. Just to let you know, we certify mainly IT products and IT-based services. We distinguish between controller services and processor services because there are, of course, huge differences. And we have right now approximately 100 auditors located in 18 countries who are the ones to really conduct the legal and technical evaluation. And then the certification body, which would be my colleagues and me, we would validate the respective evaluation report. We would ensure some sort of homogeneous interpretation of the criteria and of the law based on what the Article 29 Working Party at this point says. And then we would issue the seal. So this is basically how it works. It's a two-step approach. First, auditors conducting legal and technical checks, then a certification body validating the results. What can I tell you in terms of experiences? What is important for a future European seal that is meant to be strong and of high quality and trustworthy? There are, of course, many, many requirements here. I just want to mention a few of them. It begins all with how to identify the target of evaluation that you actually want to certify. This sounds easy. It's often not as easy as you could think it is. Think, for example, about a service to be certified. Then you would have to consider, for example, interfaces to other services. Maybe a company would say, I only want to have this and that functionality certified. And then you as a certification body would have to tell them, yes, that's okay, it's still meaningful, or no, it's sort of cherry picking and we cannot go for that. So already this initial stage of a certification is of huge importance, because if you do not know what you are talking about, then you cannot have a proper certificate in place afterwards. Another topic that I would like to highlight is I'm deeply convinced that meaningful certification requires both legal and technical evaluation. Because if you want to certify compliance of processing operations without having a look at the IT systems, then how should this be reliable? So I cannot imagine to go for a certificate that is only based on some sort of document review and some interviews with staff, because you have no proof of what is going on in reality. Other topics would be, for example, comparable level of evaluation depth. So if we talk about different certification projects, in the future we will talk about different certification bodies and even certification schemes maybe. Then in the end, the overall level of quality should be comparable. And this begins with the evaluation depth. It continues with how the criteria and the law are interpreted, and with other topics. So this is really of crucial importance to find solutions so that all of the seals that will be granted in accordance with the GDPR, with Article 42 and 43, that they have a similar quality. Because otherwise we will have many, many seals, different levels of quality, potentially a race to the bottom in terms of costs and quality, forum shopping, and a lot of other developments that would damage the reputation of certification as a whole. And this is at least what I'm convinced of. I have to check my notes, what else I wanted to share with you, if I still have the time for that. Yes, okay, the GDPR itself already acknowledges transparency to be very important for certification. I would like to stress that once again. It begins with transparency regarding the criteria and the procedures, but it cannot end with that. It also requires some sort of transparency regarding the results. I'm a firm believer of that. So what we would, for example, do is we would publish some information on the results ourselves. We would ask our auditors to write a summary of their results, of course without disclosing some sort of commercial secrets, but still providing a summary that would allow the interested public to verify what is going on and if this is really in line with the law and a good quality certification that is granted. I think I'm stopping here for now because I could, of course, talk for hours. And
thank you very much, Sebastian. Bojana, what do you think on this?
Actually, this one. Thank you. So look, this is an interesting, the certifications and codes of conduct in GDPR are for me very interesting. And when I say for me, I speak as a former privacy practitioner. I was a head of privacy at Accenture for about 12 years globally, and now I lead a think tank working with a number of global companies and regulators to kind of bridge, if you like, the two worlds. And I think there is a huge interest in the certifications and codes. We ran a survey on GDPR readiness, and it's about 60+% people said they would be ready to go for certification if it was properly construed. And so, rather than thinking of compliance burdens and so on, I think this is an opportunity. Now, it's opportunity also because it allows us to operationalize what are often very principle-based approach and high-level privacy principles. It allows also the rules and the GDPR to stay current. Today we discussed, Peter Fleischer challenged us all to start applying GDPR rules to the new reality of machine learning, artificial intelligence, and the Internet of Things. And so we're going to need some different frameworks in addition to law, right? Softer frameworks. So I think certifications allow for that softer framework. So I'm a big proponent of this. And in fact, in the GDPR, they have two functions. One is, as you have said, Sebastian, an element to demonstrate compliance. And I think we should talk about as to what that really means, because you have said quite rightly, question mark is whether actually by being certified it means I actually comply 100%. I don't think that's possible ever to ascertain, but also they enable organizations to transfer data outside the EU legally. So it's the framework for international data transfers, just like Privacy Shield, model contracts, binding corporate rules. So I think that's that potential that we need to use. Now, we actually wrote a paper on certification seals and marks under GDPR as part of our GDPR implementation project, and we gathered all the views from practitioners, DPAs, and experts, and I think we managed to crystallize real benefits for certification for a number of stakeholders. And when I talk about stakeholders, I mean, first of all, organizations. Why would a company want to certify? Well, obviously, if it helps demonstrate compliance to a number of stakeholders, that's important. To regulators, first of all, I can demonstrate that I comply. If I have a certification, I'm seen as a committed, responsible, accountable company. So I hugely support that. Secondly, to my internal management. If I get this certification, this stamp of approval, it means something. It means that what I'm doing to my board, to my leadership, I'm actually spending company money properly because I've got something to show. And to my shareholders, ultimately, and kind of other internal people, as well as my external people, business partners, really hugely important. It builds trust, of course, with the consumers and with my business partners, and particularly we found that organizations are interested in certification in B2B context. And we can talk about this, perhaps it'll be an interesting discussion, whether it's as valid in the consumer-based businesses. I think possibly yes, but it was interesting that the first thing they jumped was actually it helps us when we are dealing with the ecosystem, when we are dealing with another company, when we are sharing data, when we are using service providers, outsourcers, and so on. So there's a huge benefit, because procurement departments always asks me, is this company ISO certified? Do they have something to show that they're actually responsible data protection organization? And here it is, and that's an obvious one. And also, I think you have said it, there is this expectation that if I have a certification, I may get some mitigation in enforcement. I may get a bit of a better treatment by DPAs, hopefully, if there is a breach, because I did everything to prevent the breach, but it happened. So that's the benefits to companies. Certainly, that is clear. Secondly, to DPAs. DPAs cannot do everything that GDPR requires them to do. So the workload in terms of enforcement and supervision is huge. And in fact, we are writing another piece of paper on smart regulation, smart DPAs. How should DPAs discharge their obligations? And this is really tricky because they're expected to do so much with such small resources. So in fact, if you have a certification scheme, that enables you to share your oversight and your workload with the certification bodies like EuroPriSe, who also have got complaint handling mechanisms, right? And by default, it delivers better compliance on the ground. The more certified companies you have, it's likely that actually there's better compliance. So as a regulator, I should encourage better compliance. It's easier for me. There is also benefit for individuals, I think, because there is a trust in the system. In the consumer world, if I know somebody's certified, I may go to that website versus the other one. That still needs to be tested, but I hope that's how people would see it. And in the business-to-business world, I think there's an absolute, every reason why ecosystem would benefit from certifications, because it would help the speed of negotiating contracts, the speed of doing business. If you know that somebody is a trusted third party and I can entrust you with my data, or I can do business with you that involves data protection. So these benefits were very clear in what we have heard from all the stakeholders, but it is important that they're preserved. And so let me just say one thing. If GDPR certification becomes yet another compliance structure, yet another burden to be done, in addition to hundreds of burdens that we have already from the GDPR, and remember, companies certified to hundreds of things, Sarbanes-Oxley, ISO, hundreds of them. There's going to be another one, ENISA for IoT, I hear, security. There's going to be more and more. So, you know, how many certifications as a company do you actually have? And how do we make sure that all these certifications also sit together? And speaking from somebody with a global hat, I have to think about this. You know, there are lots of certifications that exist already, well, in Europe, some, but globally as well. There's Japan privacy mark, there's a Korea privacy mark, there's a cross-border privacy rules, now there's a GDPR. If I'm one big chief privacy officer of a multinational company, many are, I mean, what do? I go certifying one by one? So I would like us to also think a little bit under the premise of GDPR, how do we build bridges across these different international certifications? If I'm Microsoft or Google, and I already have the ISO privacy and cloud, privacy and security in the cloud certification, well, that should actually give me a great step towards GDPR certification, because I don't need to go again and achieve another one. You see what I'm saying? I think these are some of the challenges, I would say, but also opportunities. And you asked me about experiences. Look, you know, we've seen some experiences. I talked about the cloud certification has been hugely useful. Microsoft did it first. Now everybody's copying them, and the peer pressure is there. So the marketplace is getting better. So that has to be good, right? We talk about these cross-border privacy rules. This is an alternative Asia-Pacific system that is really very important. We don't have time to talk about it today, but I think, you know, as we think about this under GDPR, we're going to have to think about bridging our things with their things as well. I had a personal experience while I was leading privacy at Accenture. At that time, there were no BCRs, and we built this internal program that actually dealt with client data in the context of outsourcing IT services that the company was providing. And because there was nothing to show how good we were and how great we were in protecting client data, we actually, after we built the program, we asked the BSI, not EuroPriSe, sorry, okay, but BSI, because they did the ISO certifications, to do an annual review of this privacy program that was specifically ad hoc, special program protecting client data globally, Accenture. And you know what? Annually, they keep doing these audits. Accenture has got a certificate now, which says you comply with your own requirements, policies, and program, right? That goes into requests, into response for every single RFP, for every single IT big project that goes globally. That has also made the company much more palatable to work with, and frankly has helped also, and I always talk about this, has helped even commercial negotiations, because instead of thinking unlimited liability, joint liability, how are we going to put things in a contract, people are focusing, how do we really protect data on the ground? What is going to make it work? And this certification, in fact, you know, has helped hugely. And I think as a competitive advantage, it was an amazing thing, and the company still is doing this. I hear, of course, now there's BCR for processors, maybe the two things help. And so, as you can see, I'm an optimist, but I do agree with Sebastian. I think we've got some issues to iron, and we need to really work towards making this certification under GDPR a success.
I fully agree with both of you on the potentials of data protection certification. Sebastian mentioned earlier about the different seals and how we should map them, and you mentioned at the beginning of your intervention about the study you did on the benefits, but I'm sure that a lot of discussion will pertain the costs and the burdens. You implied that also on the data controllers. What do you think, Irene, are the experiences that, or the best practices that we could gain from existing certification in emerging sectors in order to first match different levels, different assurance level, different schemes, and the second to promote this within at least the European market?
Well, first of all, I would like to say that there are many lessons to be learned from other sectors. As we have been saying over and over again in several occasions and seminars and workshops, we don't need to reinvent the wheel in the case of GDPR certification. But of course, this does not mean that we shouldn't take into account the particular nature of the right to protection of personal data. So here, the GDPR is about the protection of a fundamental right, which might bring on several additional requirements for supervisory oversight and some more intense control from the authorities, from the data protection authorities. So there are several lessons to be learned. We can take the example of the ISO IC standards on conformity assessment, and we can see already from there how to build, how to organize the data protection certification mechanism in the GDPR. We can learn about the relationships between the certification body and the client. So in this case, is the controller or the processor, the entity that wants to be certified. Liability issues. What happens if there is misuse of a seal or a mark? So these are practical issues that we don't need to rethink from scratch. Another example is the EIDAS regulation. So this regulation was published 2 years ago. We can already see that there is one system organized there on, with seals, with electronic signatures and certifications, which is, of course, quite different than the GDPR certification. But we can see already that there have been some steps from the Commission, for instance, into adopting, implementing acts, specifying technical standards. So this is relevant to what Bojana was saying. If there is one standard that already relates to some, for instance, security requirements in the GDPR certification mechanism, then we can see how this fits into the GDPR mechanism itself. But also the experience from this, from the EIDAS regulation teaches us some other things, the risk of proliferation of schemes. Already looking at the regulation, we see that there is the establishment of the EU trust mark. And looking at the GDPR, we see the EU data protection seal. So maybe for lawyers or even for people who work on this field, they can understand that what is the actual difference between the two seals. But then I'm not so sure, actually, I'm not sure at all that a business or even a data subject, a consumer, would be able to make a distinction what is the EU trust mark and what is the EU data protection seal. So we see already fundamental issues into that can lead to legal uncertainty and confusion in the market, because in the end of the day, certifications should be seen as a tool offering transparency and clarity, and not really overcomplicating things. Yeah. So.
Thanks a lot, Irene. José, what do you think?
Well, making some alignment with the previous discussion, I took some notes. For instance, the previous panelists mentioned that if we got the standards, we can follow them. The main issue here can be how many standards are we getting. And I'm not talking actually about the privacy domain, because I think in the privacy or data protection domain there's not so many standards available yet, even though ISO is working in many different lines. Pseudonymization was mentioned today, even if it's a draft idea. Privacy engineering, working also on that means. But for instance, if we take some other ICT domains such as cybersecurity, which are, I consider, a bit ahead of privacy certification. Last week, a couple of weeks ago, EXO, the group leading this cybersecurity PPP, released a state-of-the-art document gathering all the cybersecurity related standards, and they got about 300 different standards. So this raises yet another problem or challenge, which is the fragmentation. So I completely agree that if you got some standard, at least you know what you can do. And even if you haven't got the certification, you know the path to follow. And that may help your company to improve whatever you are certified. It might be your product, be it a standalone application for your mobile, as we talked this morning, maybe a standalone system, or even might be a service, which is a bit tricky, because services are dynamic in nature. So even though you get an interface, the behavior of the service can change. And so the certification, you get it at one point in time. But that doesn't preclude you to change the behavior of the service, so that even though you got the certification in the past, you are not anymore behaving as expected. So these are some considerations for debate. We got some examples of standards that have demonstrated their usefulness in different domains. For instance, the common criteria, where there are qualitative assessment of a set of requirements. And for instance, Sebastian, you mentioned about the EuroPriSe seal has got a set of criteria. This is another important issue. Which are the criteria? Which are the specific requirements we must follow when talking about certification? Because I understand that there are different viewpoints, can be the legal viewpoints, but as I come from a technical background, I'm thinking, for instance, privacy by design. These are technical guidance. And I think that some standards are being developed to provide some guidance to engineers, to project developers on that line. Just to mention, there was a study in 2013, the EuPrivacy Seals project, which collected a set of, the state-of-the-art at that point of time about privacy seals in Europe, and they encountered about 25 different privacy-related certification schemes. And they found at that time that there was a large degree of variation in the functionality and the behavior of the different schemes. So still, there is this idea of fragmentation and how that can be solved. About guidance, I agree that standardization is a way to go, but we need to understand that testing or checking compliance with technical requirements is not improving the final result. So you can sign a problem after the problem or the product has been developed. So instead of that, standards can help to take all the requirements into consideration through the development process from the very beginning. Because in software engineering, where I come from, you know that the later you consider some requirement, the more expensive it is. So standards can help in that way too. Well, for the time being, I think.
Okay, thank you very much. I will briefly go to and ask Bojana again, because he will have to leave in about 15 minutes. She mentioned earlier that we should not perceive this as only an obligation, or my question actually is, should we perceive certification only as an element or compliance, or should we promote it as being as an element of being of proactiveness for the data controller or the data processor, and an enhanced accountability approach.
It's probably both. And what does certification mean? Does it mean I comply with the law? Or does it mean I have capability and infrastructure to comply? And I think that question about I comply with the law, I think it's very difficult to say that, because it's, first of all, to your point, Jose, it's point in time. Secondly, certifications are not done by lawyers. They're done by technical experts often. Who is to say? So the technical expert will say, yeah, she has got privacy notice on her website or just-in-time notice. But does that notice actually complies with GDPR? Who knows? So I think that's a tricky one. So I would say that, to me, certification is actually the way of demonstrating accountability under GDPR. And Article 24. So you know that accountability is a big element of GDPR. What that really means, and Peter talked about it today, is that you have to have a comprehensive privacy program with all the elements of that accountability. You have to have a leadership oversight, your DPO, your risk assessments, your privacy policies and requirements, your training and awareness, your verification, your breach notification, dealing with complaints, like all these elements. And so, in some ways, if you think about accountability as a privacy program, then you can actually certify your program that you have a program that actually satisfies accountability requirements. And I know that NIMITY is doing some interesting work. Paul, you are here, and you've got the stand out there. It's doing some interesting work where, in fact, it would actually help organizations do this certification either internally or externally to check whether they've got the elements of accountability that are going to be required under GDPR in any way. Now, does it really mean they're 100% compliant? I think that's very difficult to say, and probably the answer is no. But does it really matter? I think it doesn't matter if it helps with accountability. Now, that also means that regulators must incentivize it in that way, to say, the organizations that are certified, I assume they're accountable. I assume they're good citizen. I assume they've got a good corporate digital responsibility, and I'm going to treat them like that. So they'll have a preferential treatment. Maybe they can do more with data. Maybe they will have a benefit of a doubt when there is a breach. Maybe we'll give them some mitigation in enforcement. But of course, that doesn't prejudice my right to take enforcement action against a certified company. I can always do that. And can I make a last point? Because you have raised this, Sebastian. EuroPriSe is at the moment given for services and products. And I think that's a question you have asked us all to think about. In my opinion, in order to make success out of certification, it has to be broad. You have to be able to certify, frankly, capability to comply, which is your accountability privacy program, the stuff that NIMITY is telling people to do, kind of, right? That you should be able, in my opinion, to do that. That's what BCR is at the moment, and we can talk about that. I think you should be able to certify your product to service. Why not? You should be able to certify even your app. If I'm an app developer, it would be fantastic if I can certify that as well. Maybe even the method in which I train people, the training program. So I think it can be many things to many people to allow scalability. But I'm interested in your views. I mean, what is everybody else thinking about this? Because I know that there is a difference in opinions between DPAs as well around what should be certified.
Please.
Before I leave.
Okay, Sebastian then, and then Irene, since you had reference.
Yeah, I took some notes, too many obviously, to manage to deal with all of them. Maybe to start with, what is a useful target of evaluation to be certified? And I think the ones that are discussed most are privacy programs, products and services, to some extent also DPO certification, something like that. First of all, of course, we would have to really clarify what is covered by Article 42 of the GDPR, because it says compliance of processing operations. And there I would be pretty sure that a service would be covered. You could already debate about a product, you could debate about a privacy program, and I cannot see some sort of person certification covered by this wording. But if we talk about success, I agree that I would put it like this. I think as a first step, it's definitely useful to have a look at the privacy program, because it's at the core of everything that is going on. On the other hand, even if a privacy program is in place that meets all of the requirements of the GDPR, there can be single processing operations going on that totally violate the law. So if you want to go for certification of compliance of processing operations, then I think there should at least be a second level where you have a look at products and services. And here some other topics come into play. First of all, we really try to go for full compliance. So we have legal and technical experts, and also at the certification body we have legal and technical experts. But you can imagine what this means in terms of costs. So you cannot offer this seal to a small or medium company, small or medium enterprise, to a cost that will really make all of them move towards certification. It's not possible, and we know about that this is some sort of a shortcoming here. But anyway, we really try to go for this full compliance, and there are a lot of companies out there that are really interested in that. And have some maybe innovative services, and they are not totally sure if they really fully comply with the law, and they want some guidance, and sometimes DPAs are not ready to give it, or whatever the reason may be, they contact us and say, we really would like to go for the seal. There are a lot of new legal and technical issues involved here. Please provide guidance to us, and we want to go for certification. In respect of services, it's absolutely true. Certification is a snapshot. And you could, as a company, the very next day, you could just switch to another, I don't know, default setting or whatever, and then the whole thing does not comply anymore. This is a core weakness, and I have to be, and we all have to be honest about that. This is possible. If somebody wants to deceive the outside world, then they can probably manage. What we did with EuroPriSe is we came up with monitoring after 8 months and after 16 months. After 2 years, then recertification is regularly required. And if a service changes frequently, then the service provider has to go for early recertification. Of course, in this world where everything changes very frequently, this once again is kind of a burden for a company to really deal with that. And of course, we try to find some pragmatic solution to really not have all the checks conducted every few months, because that would be absolutely too much. But this is the question, quality versus costs and efforts. And with EuroPriSe, until now, we decided to go for quality. And of course, you can discuss if this is the right level or if it should be a little bit easier for companies, whatever. And the last thing maybe about the development phase that you mentioned, José. This is, of course, the ideal time to initiate certification. It's also dangerous because evaluators and certification body are not allowed, of course, to consult a company, because otherwise they would afterwards judge their own work. So it's an ideal point in time to start a certification. We usually require some sort of at least mock-up or something like that, that then is to be certified, so a concept would be not enough. Ideally, at the end of the day, you would be able to grant the seal the very day that a service goes operational. And there are some solutions for that. We managed it from time to time to do it without violating the principle of being independent and impartial. So it's possible, but it's challenging. And as a certification body, you have to be very, very careful that no consulting is going on.
Thank you very much for this, Sebastian. Irene, what do you think?
Yeah, well, there are several topics raised here. So first, what does compliance, whether certification guarantees compliance? I would say no. Having a privacy notice does not mean that even if you follow the requirements of the law, does not mean that you comply with the law in a continuous manner, or that there are also other aspects like the principles being taken into account. Complying with being certified, GDPR certified in the sense of Articles 42 and 43, it rather means that you conform with the requirements that are included in the certification scheme, which is based on the GDPR. So in some sense, the requirements in the scheme are not different than than the GDPR, but it's not the same thing. So this is the first thing. Then second, yeah, what should be certified? This is certainly a long discussion. Sticking at the letter of the GDPR, as you already mentioned, well, Article 42 mentions processing. So in that sense, we could say that processing also may include a framework, a privacy management, data protection management framework, but the strict letter of the law refers to processing activities. But of course, looking at the recital 100, we see that there is also a reference to products and services. So there is some issue of interpretation there. About the certification of products, with some exception perhaps of security aspects, data security aspects, for me it's difficult to imagine how there can be a certification for a product saying that this product demonstrates compliance with the GDPR. And there are two main reasons for this. One is that data protection also depends a lot on the context. So if you certify in advance a camera, then you need to see how it works in practice in order to be sure that all the issues are taken into account, how it processes data, how you're going to see if, for instance, it respects data minimization, if you don't know what is necessary in a specific context. So this is the one issue. And the second issue is that the GDPR is a regulation that assigns requirements to persons, so natural and legal persons. It does not assign product requirements. So it's always the controller or the processor that are responsible to comply with the regulation, not a product itself. So from that perspective, product certification of products in the sense of the GDPR is also not really what's in 42 and 43. And then for the function of certification as providing guidance, or a certification body providing guidance, I think this can be perhaps a secondary function of certification of the whole process, not certification as such. But in any case, we should acknowledge that there is sometimes, or most of the times, there's quite a heavy procedure. It can be quite expensive. So there are also other tools that may be useful in that respect for a kind of a self-evaluation. So in that sense, I would see certification more as what is in 42 as demonstrating compliance, but not actually the organization. Yes, the organization should not wait the certification to show to take measures to comply. This is only the externalization of an organization having a tidy house. Let's say it like this.
Thank you very much, Irene. I will have to thank Bojana for joining us because she has to leave. I was thinking while Sebastian was discussing the EuroPriSe approach, imagine what would have happened if Microsoft, while they released the WannaCry patch, they had to undergo not your certification, but a specific certification. It got delayed, and then the patch did not reach the recipients. So I'm trying to see, as Irene identified earlier, we need to be scalable in terms of what we want to certify, up to which extent, because we cannot certify everything. We cannot certify something, a product, if I remember she mentioned, being fully GDPR compliant. So similar to common criteria, we might need to end up with different levels. I'm doing the analogy with ICT security, but she also mentioned the cost aspect, and I think you also brought it up earlier. What do you think, how scalable do you think this future certification framework should be, especially for SMEs, and how this can be better communicated or perceived by the EU citizens in terms of building actually the required confidence or trust in specific products or services up to the level that they are certified against?
Okay, maybe first one comment regarding products, maybe explaining the approach that we take. And it's absolutely true, if you certify a product, then you cannot be sure that the product is used by the buyer of the product as the GDPR requires. So what you can do, what you can certify is you can have a look at data protection by design and by default, for example. What we would require some sort of guidance for customers. Dear customer, please note that you will be the controller when using this product and that you should take care of this and that. It's not meant to be a legal text exactly, but it's meant to just provide some guidance to the customer. And then we would argue that this product facilitates its privacy compliant use. So we would never claim that everybody who makes use of the product is in line with the law. But I think it's still useful to have something like that, because then really the manufacturer or vendor of a product could have some sort of approval that they could show to their customers that they make it easy to use this product in line with the law. So you can discuss if this is the right approach under the GDPR. Actually, I think it's a possible approach, and it's backed by, as Irene already said, by recital 100 to some extent. Of course, this is not the legal text of the GDPR, it's a recital. But in the end, I think product certification for me still is something that makes sense also under the GDPR. And actually, once again, we really try to achieve full compliance with the law. Maybe this is an approach that can only work for some cases, because it produces a lot of efforts and costs, and we will have to wait and see how the discussions develop and what types of seals finally will be the ones that prove to be most useful. But we actually try to go for that until this very day. But it's a huge challenge, I have to admit that, of course. So when talking about SMEs, I could imagine that really having more kind of an accountability approach and having a look at the privacy program could be a suitable approach for SMEs, because then you could maybe really limit the whole thing to a document review and maybe some sort of interviews with the company. There would not be a need to have both a legal and a technical expert involved. And so you could probably make this cheaper. And also the two-step approach that we have, and I believe in that, for the product and service certification, maybe it would not be necessary for this sort of a certification. So I could imagine that this is a tool for small and medium enterprises that they could really afford. Depends a lot on how this would look like exactly, of course. But I'm not saying it's a bad idea. For others, it could be a first step, and then on top of that, for example, a certification of a product or service could be built. So what we can see from our experience, or what I can tell you from my experience, is that until today, only few small and medium enterprises really try to go for this EuroPriSe certification, because it's very challenging, and those were companies that really have privacy as their unique selling proposition. For example, we certified a privacy-friendly search engine called Startpage and XQuick, and for them it's so important to really differentiate from competitors that they were willing to invest a lot of time and money. For others, this would be too huge. In terms of awareness, I think it's very important to have one strong seal brand, to have one common baseline certification in place with probably one seal image that is easy to recognize, so that citizens and consumers can easily see, okay, this is the seal that I have heard about, which is trustworthy, and maybe there are different kinds of this seal. And this, of course, has to be dealt with in full transparency, because otherwise you begin again to confuse and deceive the citizens and consumers. But this is important to really have one strong seal brand, and this is what our customers tell us all of the time. Please try to do whatever you can to prevent that we have fragmentation with the seals. It's also for the customers. If you think of this B2B situation and they are asked for a strong seal, and then they have to choose between 20 or 50 or 100 seals, and nobody knows exactly about the quality of all of them. It's, of course, a huge mess. And The other thing, of course, public awareness campaigns. This is something that member states and probably the EU could take care of, and maybe some interested companies that want to promote such a seal. So basically for us today, we really hope for our customers to market our seal, to make it visible, because in the end we are a relatively small company. We have many experts, but the certification body is not as huge. And we really are dependent on that. So probably the seal holders will be one important element, and some public awareness campaigns would be another very important element.
Thank you very much. José, what are your thoughts first on the scalability, taking the SME approach, and then on how EU citizens could better perceive the envisioned seal marks and certificates from such a certification scheme on data protection?
Okay. Well, about the scalability issue, one thing to consider, we have been talking just in the 1 hour, we have been discussing about seals, about different products, processes, people, and we didn't talk yet about different domains, Internet of Things, smart wearables, cloud computing. So the diversity of different cases that should be covered by this certification is huge. So one point here about the scalability, I think, is that it's clear that one size does not fit all. And that mandates for a, so to say, global framework, at least in Europe, so that flexible enough to be adapted to the different cases. Considering that at least there should be some minimum baseline requirements that identify which essential requirements should be met by all these different certificates or certificate cases. Well, as I said, that might depend on the domain we're talking, IoT or cloud computing, big data, whatever, and also on the type of consumer, because we have mentioned here B2B, but this is a different type of consumer of the certificates that the individuals, the citizens. And I think the details of the certificate should also be different, at least how we present the results of the certificate to them, because otherwise, I mean, consumer or citizens will not understand what is presented to industry. But industry needs further details on the fine grain of the certification process and the outcome of the company, for instance, for procurement, you mentioned before. Regarding how to address the small, medium enterprises, well, I guess that having just one type of certificate won't work. And getting the experience from other domains, I mean, certification means, in the pure definition, that a third party assess your system, whatever it is, product, service, whatever, against a defined set of criteria. Okay, but that involves a third party in the process. So we can try to relax the terms and go for, in different cases, for self-assessment. And in different domains, that was the way to go. With self-assessment, usually you get your company or your organization knowing the criteria against which you need to meet the requirements, and then you do the work. And you know the requirements so that you can assess if you are compliant or not. From there you can move to certification, and in between there are some mixed models that are appearing where a third party is not certifying everything, but is carrying out random audits to the self-assessment different organizations are providing. And for instance, could be one model I know about, they are carrying out these random audits at least once each 2 years. So that may be a way to go to both meet the needs and the efficiency of SMEs and also the big players and companies. Because otherwise, you are taking the risk of putting these small and medium enterprises out of the market, because it was mentioned before that it can be a requirement for public procurement. So, yeah. Something about the users and the consumers, the citizens' perception or certifications. Well, as you mentioned that you need a strong brand so that consumers can recognize it, but it also involves that there are some fragmentation of different certification and seals, and that's risky. In cybersecurity, for instance, currently they are discussing the EC to provide a meta scheme so that some other organizations and third parties can implement that meta scheme according to different requirements and different criteria in different domains. But all of them should have the same brand recognition and then be audited by the DPAs or whatever. Of course, citizens need to accept and perceive the risk implied in the seal or certificate or the mark, but still we don't know, or I don't know how to achieve that. Within the TRUESSEC project, this is one of the goals, and we will have some results by the end of the year, analyzing the public discourses and the different surveys in Europe regarding citizens and the certificates and seals ideas. But there's a need to introduce design considerations and also computer-oriented considerations so that the business enterprises can go into the details. So that might be.
Thank you very much. This scalability you mentioned, and it was brought up by all of you, if I'm not mistaken, is one of the possible way forward towards this pan-European data protection certification framework. You mentioned different domains, different aspects, different type of consumers, as you call them, meaning data processors and data controllers. And you also brought up the issue of the discussion going on at the European level currently about the ICT security certification. My thoughts on this, and afterwards I would like to open the floor for questions for the next 20 minutes for the audience, is that in one sense data protection is in a better situation than ICT security is because of the lack or the limited availability of standards currently and existing approaches at a European level. Given the visibility that GDPR has received up to now, and we expect that in the next 2 or 3 years it will only get better visibility, more visibility, we think that's a really good opportunity, or at least I think that's a really good opportunity for such a framework being flexible enough or scalable enough to be defined and properly implemented at a European level. So I would like to open the floor for questions. As I said, we only have 20 minutes, then we have to leave for our dinner, so if you can please be a little bit precise and short in your questions. Thank you.
Thank you. I try to be very fast. Investors would like to invest into IoT devices, right? And they want to have legal certainty. The GDPR is asking about technical measures. What is the catalog I need to fulfill as a company to cover those requirements? So I see the request for, so you mentioned the baseline requirements, which is a very good starting point, right? So if we could define those baseline requirements and then come up with a procedure how to evaluate if it's properly implemented and how is it implemented, and this could be a certification or not by a third party or a self-certification or whatever, but I'm waiting for such catalog, right? And I would love to see that.
If you don't mind, I will go through all the questions and then we can conclude.
I see the benefits of using certificates, but how about using privacy impact assessments as a mean of compliance demonstration? it's not about compliance. Compliance and accountability demonstration.
Thank you for the panel discussion. The sort of question I wanted to ask seems to flow through from everyone's discussion. And the thought I had was that, related in some of my experience in information security, and it was often said historically that, at first anyway, that security was not a product, it was, or a service for that matter. It was more of a process. And as time went on, it seems to me that more security people and industries are heading towards that security is not actually even a process. It's getting close to being a culture. And I see the GDPR in the same fashion. And I would just ask for further elaboration on the process of certification and culture in that sense.
So, based on your certification and evaluation experience, and which kind of standards or which standards have you considered to be so far or found to be so far the most useful and efficient ones, and which are the ones that you're really missing and things that should come up and be developed?
Any more questions? So I would like to open the floor to the panel.
Yes, please allow me one further remark regarding the domain approach first, because I think it's a good idea to really go for more tailored certification criteria for specific domains. Often cloud computing is mentioned, or mobile apps. From my practical experience, one challenge here is that if you talk about a mobile app, for example, these days, we are approached by companies and it turns out, okay, the mobile app is related to a web portal. And maybe this is all cloud-based. So you cannot separate things as clearly as you probably would like to do it. I'm not saying that it's completely impossible to come up with some specific criteria for domains, but it's also not an easy task. We contemplated this several times and always realized, okay, it's a huge challenge and we are not sure if the time is really there to go for that for us as EuroPriSe. Still, it may be a good idea, but I think there is very, very careful thinking required in advance, because otherwise you will realize afterwards that the certification covers some important aspects, but leaves aside many others for many of the certified, whatever they may be, apps or cloud computing services or whatever. In respect of the catalog for the TOMs, I can invite you to have a look at our criteria document, which is publicly available. We have some sort of set of technical and organizational measures, which was originally set up based on experiences with common criteria and also ISO 27000 and stuff like that. It also, to some extent, addresses this topic of security being a process. So information security management system is addressed in this catalog. And I agree that this is a process and that it's very important when talking about recertification, for example, to have a look at the process in total. So the state-of-the-art changes, you have to keep track of that. You cannot simply recertify something and saying, okay, it's unchanged, everything is fine. You have to really have a close look at what is going on and think of security breaches, known vulnerabilities, the state-of-the-art. If anything is there that has to be considered and that needs to be fixed. So this is really, really important. I agree on that. The standards that are useful, maybe let me begin with IT security standards that are around. So within EuroPriSe, to some extent, an applicant can benefit from a valid ISO 27000 certification, as an example. Of course, this starts with the scope of this certification. If the scope of our certification and of the ISO certification is a different one, then it's of no use for us and we can completely forget about it. And also, it was already stated, when considering IT security standards, then you have to keep in mind that data protection is a fundamental right and that IT security primarily deals with assets of organizations. And of course, there is a gap between the two of them that has to be covered by a meaningful data protection certification. Finally, for us, it would not be sufficient to simply be presented a certificate stating we have been certified, but our auditors would need to have the possibility to have a look at confidential documents as well, to really find out about what is actually happening there. You can discuss, and we do that, to what extent this is necessary. What I want to say is, within our current certification framework, it is possible to some extent to rely on IT security certifications and to benefit from that. Of course, it does not mean if you have a valid IT security certification that it's an easy thing to go for a EuroPriSe or another data protection certification, because there are huge differences there. Of course, other standards, like for example, the ISO 27018 standard for cloud computing can be helpful when we talk about this domain approach once again. Still, there always has to be some sort of gap analysis, what is covered by this standard and what is maybe not covered but should be evaluated nevertheless. So I think it makes a lot of sense to find out about standards that kind of allow a data protection certification to be done more smoothly and really to benefit from what has already been invented in other fields, to call it like that. And this also brings me a little bit to the final statement. I understood we should make it right now at the end. Okay. So I already mentioned that I'm a firm believer of a European approach and of a European baseline certification. We heard from other speakers, and this is my experience as well, that the demand for data protection certification under the GDPR is really great these days already, so we should not waste time. I think it does not make sense to reinvent the wheel, but we should really rely on existing certifications that are there and build on top of that really the future certification framework and not start from scratch discussing about each and every detail, because then we will end up in 2020 or whenever and still there will be no certification in accordance with the GDPR available. And this would really be a huge pity. And also this awareness of companies right now with the GDPR approaching, this is of course something that could be used to go for certification and really to make companies commit even more to the future legal framework. It's clear that we can only start with the future certification when the GDPR is applicable, but EuroPriSe, for example, would also be open for some sort of pilot projects with data protection authorities. It's one thing to discuss about topics, and it's of course necessary to do that, as particularly as a regulator, but it's another thing to learn about certification as it works in reality. So I think I will propose that I do it right now. I let data protection authorities know that EuroPriSe would be ready to go for that, and I'm sure that we would find customers who would say, yes, we should start with something like that already now. It would be good for us to have DPAs being involved. And I will, of course, approach single DPAs with this idea because I think it's also helpful for them to really make experiences on their own.
Thank you very much, Sebastian. I understand that the Working Party 29 is already working on an opinion on the matter, so until the European Data Protection Board takes over, maybe it will be a good opportunity to do a pilot, as you implied, or you said, or even something in between. I don't know. José, what do you think? On the questions and then your statement.
Okay. About the question, I take some brief notes. Requirements, criteria catalogs, you mentioned, where are they? Well, for some guidelines, I know this code of practice by the Article 29 Working Party might be giving some guidance, but also I know that ISO is working hard on developing some of these standards for specific technical areas. For instance, pseudonymization or anonymization. Probably Kai can provide further details on that. And for instance, ISO 27550 on privacy engineering, which is aimed to provide some guidance, some framework on privacy engineering. But they are still work in progress. So as far as I know, there is no consolidated guidance, but will be, hopefully, sooner than later. About Kai question, trying to relate to that, efficient of standards and what are we missing? Well, I got the feeling that ISO could be the organization best prepared to address all these different guidance required. And indeed, they are working on that. But I've also heard some opposition on relying on ISO as non-European centric organization for implementation or for delivery of guidance regarding GDPR. So I know there are some discussion there going on. So I can't position on any side because I don't know really details. But at least I know there are some discussion ongoing. Well, certification and culture and some question over there regarding if they can provide the culture in the organization. Yes, sure. I completely agree with that sentence, that statement. And indeed, even if you are not certifying or finally certifying your product or system, whatever it is, at least you are carrying out a process that allows your organization to learn and to apply knowledge to the process. So indeed, that's useful to get the culture and the knowledge within the organization. So finally, as final statement, so to say, there are many challenges ahead. I think that there's no one solution for all the problems, so there should be some kind of framework addressing or allowing for different flexibility and scalability, some of the issues we addressed. I think that the standards are playing a key role there to meet some of these challenges. And well, just the add moment at the end of my speech. In the project I'm involved in, TRUESSEC.EU, you got some flyers in the desk, the entrance. We are working on all these issues. We just started this year, but we are creating a place for debates online so that everyone is invited to go there and provide opinions and comments and to address the question that some others are proposing there. So that would be.
Thank you very much. And lastly, Irene.
Yeah, actually, this is a very nice idea. So congratulations. Hope it works out. Yeah, so with regard to the question about the catalog, we had this discussion kind of during the lunch. There cannot be one single catalog because it's simply legislation. It's not only a purely security issue. So anyone is free to comply with any means at his disposal with the legislation. So a catalog would, with recommendations would just limit this possibility to people to comply with the legislation. But of course there can be guidance, and we hope that the ADPP will take on the opportunity to provide guidance on several open issues in the GDPR. And also I would like to draw the attention a bit to Article 43, paragraph 9. So the possibility that the Commission has to adopt implementing acts specifying standards on certification. So maybe this could be kind of a solution for your request. Then with regard to certification, raising the culture of data protection, well, I think this is the same. This goes for every soft tool in the GDPR. The same goes with data protection, impact assessment, or codes of conduct. These are all soft tools that enable this accountability principle and all this culture of proactively caring and complying with the legislation. yeah, and with regard to the kind of what can we use from the existing standards, there are a lot of standards that are relevant, as you mentioned already, in relation to security, this ISO IC 27000, but also I would highlight again the conformity assessment standards, because it's not only about the subject matter of certification in relation to GDPR, but also how we're going to, this system will be organized in practice. And there are also standards in relation to that. And I agree that the ISO standards are not developed in the European setting, but quite sometimes they are, or most of the times, are adopted as European standards. So this means that they have relevance to the European market as well. And then, as a closing point, I would like to say that I see certification as having many, bringing many benefits to different actors. So this is data protection authorities that we didn't talk so much today about. So it can be an enabler for them to audit organizations. Also SMEs, so it can be a point of competitive advantage or a way to enter a market. And of course, data subjects and individuals, as long as the seal or the mark is clear enough and signals exactly what has been certified. And of course, I also see many challenges ahead. I would not like to go through again the challenges, but I would really like to say that we hope that the data protection authorities will collaborate on this topic and will try to avoid fragmentation and proliferation of certifications.
Thank you very much. I said that I wouldn't dare to challenge a lawyer. You mentioned about the implementing acts. My personal view on that is the Commission should issue implementing acts on several aspects, but not on standards, because it will take some time to develop the standards or to make sure that the market indeed will comply with the standards or favors the standards, and then the implementing act might also take some time. This just
to clarify, yeah, I'm not referring to standardization request on the basis of Article 10 of Regulation 1025, 2012. I'm referring to Article 43.9. So this is something similar to what happened in the EIDAS regulation.
In the trust mark and
there is this decision from the Commission specifying a list of standards that can be relevant.
Okay. So I would like to thank first of all our panelists and ask you to give them our warm applause. I would also like to thank you for being here today in the first day of APF, and I will pass on the floor to Erich